Hello, my name is Michael McLuhan, and welcome to Startup Global SoCal. This is our fifth of 6 events where we help startups and high-growth companies grow into the global markets successfully and competitively. So the first thing I want to say is go ahead and put your name and your company in the chat. As you'll see in this series and all the other events, we're very collaborative. We're here to help you. So if you let us know who you are, what your company is, and what you're doing, it might help the panelists and experts sculpt their responses. So as I said, welcome to the 5th of 6 events. If this is your first one, we will have all of the events archived with all the resources and tips and tricks and tools that we discuss there for you, and we'll put that information and a lot more in the chat through the hour. Next week we have our final one, which is the deep dive, where we're going to bring in 2 fictional companies, which will represent pretty much every startup that's out there. So there's something that's really up everybody's alley as far as what they're trying to do, growing globally. So tonight we're going to talk about intellectual property. Now, there are a lot of different facets in the regulatory space and the legal space of building a global company and expanding and growing cross-border, but there's none more critical and more important than intellectual property. So this is about defending everything your company stands for and also protecting all the blood and the sweat and the tears that you put in to your company. I want to recap a little bit of what happened last week, because I think it really sort of defines and represents what we're trying to do here. Last Monday night, Stephen Chung of the World Trade Center and Los Angeles Economic Development Corporation asked our entrepreneur of the evening what it is that she would recommend, or what was the most important thing in her mind about taking her company global. In her case, she was acquiring foreign competitors. And she said, and I'll quote her, "The most important thing is to have connections to the people who know everything, so that you can learn along the way and be able to ask the smart questions to them and get the smart answers from them to keep up with the pace of your change and your growth." And what we're presenting tonight and through this whole series is the experts that have those answers. And as I said earlier, we're collaborative, and without the startups and the founders coming to us, we can have a great time and share things and put on great programs, but we're here to help you. And we're here to deliver the resources and the programs and all that will support you in your global growth. So a little bit of housekeeping here. Tricia will do an interview, as we always do, with an entrepreneur. In this case, it was a former in-house counsel for a major US brand. And then we'll move to the panel for expertise and experience and guidance on intellectual property, how to prepare and defend your company around the world. We'll have the chat going all the way through. If and when you have questions, please be sure to put them in the Q&A box. Okay, not the chat, but please put them in the Q&A, as Tricia will go through that and bring the questions to the panelists. So I want to thank the sponsors, the Global Innovation Forum. The Startup Global event is theirs. They've done it around the country in major metropolitan areas. And here in Los Angeles, we're honored that they've chosen us in our market to do a multi-series, multi-event process to share everything with you, not only SoCal, but around the country. LMU, their business school, is a great resource here in Los Angeles. The U.S. Commercial Service, the best resource that you have for guidance for pennies on the dollar. If it's not free, that is. LAVA's Global Lava Community. LAVA stands for Los Angeles Venture Association. If you're a founder and you want connections and help and guidance with meeting investors to fund your international expansion, that's what LAVA is all about. I'm honored to be the chair of Global Lava, so I'll put my information on in the chat. You can contact me for that. And the International Business Accelerator, which is my company, we help startups and high growth companies with cross-border growth. We do it compliantly and quickly and profitably. So last but not least, thanks to the host and the production partner at the Milken Institute. They also have a lot of data and resources for LA and Southern California companies who are looking to export. So I think I covered it all. And as I said, Trisha will be doing an interview with an entrepreneur from the private sector startup experience, and then she'll move on to the panel. And then I'll be back to cover anything I missed, and then also give you some information about next Monday's event and then the entire series as a whole. So, Trisha?
Michael, thank you so much. Good evening, everyone. I am delighted to join you. I am Trisha Van Orden, Deputy Director of the Trade Promotion Coordinating Committee, which is part of the International Trade Administration, which is part of the U.S. Department of Commerce. I'm based at Commerce headquarters in Washington, D.C., and I'm really excited to join my colleagues based in Southern California and all of our great partners in the LA region for this program. We have a really great lineup tonight. IP is a really important issue for startups and early stage companies, and I'm really pleased with the expertise that we've brought together. Before we get to our panel, I am so excited to have Deborah Greaves with me this evening. Deborah is now a partner at Withers Bergman LLP, but she formerly was the Secretary and General Counsel for True Religion brand Jean. So we're gonna start off with a quick chat with Deborah to really think about her perspectives from within a company and how she approached IP, and really what it means to develop an IP strategy. So Deborah, thanks so much for being here. And I want to kick it off with just some basics. What is intellectual property, and how should a business approach its intellectual property portfolio?
Thank you, Trisha, and thank you to the sponsors for inviting me to speak here tonight. So I look at intellectual property as a company's creative assets. It is what defines a company and gives them really, in most respects, purpose for existing. The intellectual property comes in different types. You have it on goods, we're talking trademarks now, and you have it on services. And in the case of trademarks, these are really designed to protect consumers so that they can rely on the source of the good or the service. So we think of trademarks as a source indicator. Some examples of trademarks are Apple or Hewlett Packard or Ford Motor. Those are trademarks. We also have copyrights, and copyrights are designed to protect the creator of the content. Copyrights cover goods such as artworks, publications, music compositions, music recordings, graphic arts, movies, television. And so anything that's got creative content could be a copyright. And even for companies, your logos often can be the subject of a copyright as well. Then we have patents. Patents are designed to protect the inventors. And you have a couple different types of patents. You have design patents and you have utility patents. And when you think about patents, what you might think about are things like pharmaceuticals, engineering type things, chemical creations. But then from the design aspect, it could be something as clever as a new purse clasp or a novel belt buckle, something, you know, that the design is novel and hasn't been subject of a prior art, so that it is registrable as a unique design. We also have trade secrets. Trade secrets is the one intellectual property that's not registrable. And so you as a company have to be proactive to protect your trade secrets. And the way you do that is by putting in place processes and procedures to prevent the disclosure outside of the company. And we usually do these with confidentiality agreements or non-disclosure agreements. And trade secrets are things that are unique and important to your business. So it could be your customers, your pricing, your sources of supplies, your formula, your processes, your methodologies, your molds, your fits. All of those different things could be subject to trade secret, something that you don't want your competitor to know, and that gives you a competitive advantage. There are some other types of intellectual property, such as trade dress, but I really just wanted to give an overview and not get too deep into the woods.
Deborah, thank you so much for setting the stage for what is intellectual property, what we're talking about this evening. Let's go up to your experience with True Religion. It's a popular, well-known brand, which I understand had problems with counterfeits. How did you protect the brand and the product?
Well, with any company or product that is subject to counterfeit, there's a lot of different things you need to do to be proactive to protect it. And the first is that you need to register your trademarks or the other intellectual property that you're trying to protect. It might be that you need to protect a patent. It might need that you need to protect a copyright. But the first stage is to register it in your home country. But talking about going global, it's very important to register that intellectual property internationally. I mean, IP protection is territorial. So just because you have a trademark registration in the United States does not mean that it's going to protect your mark anywhere outside of the United States. So you have to know that as you go global, that you need to protect your mark by registering it in other countries. And this can be very, very expensive. I've heard people say before, oh yeah, I want a global registration. I'm like, maybe you don't, not if you're a startup, because that could be, you know, $100,000 or more easily. So you want to be strategic, where you should register, when you should register, what you should register, what you should cover with the registration. And also know that within countries, you can record your registrations with the customs agencies in those foreign countries. Now, what you get by virtue of a customs recordation varies by country. For example, a customs recordation in the United States can actually stop the import of counterfeit goods. But in other countries, it won't stop the import. What it will do is it will allow you to get a notice that the goods are coming in, and then you have the opportunity to object to the entry of those goods by filing a lawsuit. So the benefits of recordation vary by country, but what's most important to know is that you cannot record your trademark unless it's registered. The other thing about enforcement is that you really need to have a toolkit. It's not one solution fits all. There's a variety of different tools, not only depending on how the goods are moving, but where you're seeing the counterfeits. So enforcing counterfeits on the ground at flea markets is one set of tools versus enforcing them online, which is another set of tools. And if you develop your intelligence properly, you can get to the point where you can do factory raids and actually get to the counterfeit at the source.
It sounds like some exciting times raiding the jeans factories. Looking back at your time at True Religion, is there any aspect of IP strategy you would have handled differently?
Well, what's so interesting is that I didn't start with True Religion when it was at its inception. I joined about 4 years after the company was formed. And I think that even if I had been with the company at its inception, some of the things I learned along the way, I definitely would not have known at that time. What I can say looking back is that trademark clearance is a lot more than just making sure that no one else has registered your mark in the United States or elsewhere in the world. A lot of people, when they first start out and they choose a brand name, they maybe clear it in the US to make sure it's okay to use. And that may be good for the US, but that does not mean that is good for other countries. First of all, if you clear it in another country, that clearance is just good for today. 6 months from now, you need to clear it again. And by then it may be too late. Someone may have taken the mark, registered it, and many countries, they have trademark laws which say that the first to file the application has the senior rights. So you don't want to sit and wait too long before you go and apply in that foreign country. But the other thing you have to think about is registrability. We in the United States are used to having free speech. We get very sometimes racy and edgy with our trademarks, but sometimes those racy and edgy trademarks are not going to be registrable in foreign countries. That's the problem we had with True Religion. It was the word religion, and we had a lot of issues with that. But if I look at some of the trademark cases that have gone before even the Supreme Court in the last couple of years, like for the mark FUCT, which was initially denied by the Trademark Office as being offensive and vulgar, and ultimately the Supreme Court overturned that on First Amendment free speech grounds. They don't have that in other countries. So while you may have the success of getting that mark registered in the US, it does not mean it's going to be registrable anywhere else. And I encourage people to be sensitive about political, religious, and offensive within that country type marks, because that's where you're going to run into the issue where you're just not going to be able to register your trademark.
And one last question for our time here. What advice would you give to a small company just starting its business when it comes to its IP strategy?
Well, I would say don't skimp. Make sure that you allocate a good budget towards your IP protection, whatever it's going to be. And think global. Don't think, oh, global 5 years down the road. Think global now, because 5 years from now, it may be too late to protect your IP in that foreign country. So always have a portion of your budget allocated for building your portfolio, whether it's domestically or internationally.
Thank you very much, Deborah. Very sound advice. I really appreciate you joining us. And if you don't mind sticking around for our audience Q&A towards the end of our session, and I'll have our panelists join us now. We'll switch over to our panel. Deborah, thanks again for those insights from your time with True Religion.
My pleasure. Thank you.
Really excited to be joined by our panelists. We've got 3 lined up this evening, including Brian Peck, who is the director of the Transnational Law and Business Center at the USC Gould School of Law, and he also serves as an adjunct assistant professor of law. We've got Raquel Cohen, who is my colleague at the U.S. Department of Commerce. Raquel is a senior intellectual property and trade policy attorney based at headquarters with me. And then we've got Lori Kozak, who's a partner and also the co-chair of the trademark practice group for the firm Fox Rothschild. So I'm very excited to have you guys all join me. And as a reminder, if you have questions that come up during our discussion, please add them to the Q&A box. And Brian, I'd like to start with you. Deborah went over a number of kind of concepts related to intellectual property, but can you kind of take us back and just as a startup, what are some of the key things to know for protecting intellectual property before entering overseas markets?
Sure. Thank you very much, Tricia. And again, I'd like to also thank the organizers and the sponsors for providing the opportunity for this event and for allowing me to participate in the panel. I'm honored and pleased, and good evening, everyone. So thank you for that. So yeah, as you mentioned, Tricia, I think there are, to simplify it, but still focus on the key points, there are 3 what I consider basic things that you need to understand or know about IP before you actually enter into an overseas market. First is the one that Deborah already mentioned, that is that IP rights or IPR are territorial. You know, if you want to protect your IP and enforce your IP in another market, you have to go register that IP, whether it's a trademark, a patent, a copyright in that market. There's no such thing as a global trademark or a global copyright or a global patent. So you need to remember that IPR is territorial, and you need to think, as Deborah mentioned, you need to think ahead. We used to tell when I was in private practice that if you were even thinking about going to China, you know, start the process now, even though it might be 5 years down the road before you actually enter that market. So you need to remember that it's territorial. Secondly, IP rights are private rights. That means that you are responsible for protecting and enforcing your IP rights. The government provide the framework, the legal framework for you to protect and to enforce your rights. But it's up to you, either through your own resources or if you have a local partner, to ensure that your rights, once they are secured through registration, that they are protected and, if necessary, enforced through the legal systems that are provided by the host country in that market. The third key basic is that you need to know the local rules. Everything from how to register for your particular IP, how do you protect it, how do you enforce it. For example, you know, some countries, the term of protection for trademarks is 7 years. Other countries is 10 years. For copyrights, some countries it's 50 years. Other countries it's 70 or more years. So knowing the term of protection. Secondly, you know, how do you register? For some countries, the person that has the superior right for a trademark is the first to use it in commerce. That's the system here in the United States. In other countries, including China and some other large markets, it's the first to file. So it's very important to know how, what is the local rule for registering your particular IP and the process for doing that. It's also important to know how to enforce your rights, everything from the statute of limitations, how much time do you have from the infringement to bring a case in that home market. The threshold damages, what is the amount of damages that are necessary to be able to file a legal case against infringement. Knowing the forum or the venue, in some countries it's a court system, in others it's an administrative agency system to enforce your IP rights. So again, these three key things are IPR is territorial, it's a private right, and you need to know the local rules.
Thank you, Brian. And Raquel, I'd like to turn to you next. As Brian said, you need to know the rules. Well, the great thing is the U.S. Department of Commerce has a lot of resources and guides. Can you talk a little bit about what is available online to answer some of those questions? And then also give some advice as to when a company should start to develop their international IP strategy?
Sure. Thank you, Tricia, for the question. And I want to say it's a pleasure to be here this evening with everybody to discuss intellectual property. It's one of my favorite subjects, so I enjoy this discussion. I'm going to take the questions you just posed reverse. I'm going to flip that. So let's first tackle how a company should start developing their IP strategy globally. So as an IP and trade policy attorney for the U.S. Department of Commerce, I tend to see a lot of companies come to me at the end of this process, meaning they have already started doing business globally and they're facing some trouble, whether that's small or large. So I want to prevent everybody here listening to this discussion from being in that spot. I hope you don't call me for that, but I'm here if you need me. I'll give you my email address as well. But let's discuss, how you start thinking about it. And I really emphasize US companies to think about global expansion and exposure from every initial exposure that they're touching consumers, distributors, suppliers, websites, venues. So you have to just think about it from a perspective of, are you going to be at a trade show? That's exposure there. So a consumer or a competitor or another country, in some cases, can get a hold of your brand, your product line, your invention, and that is already exposure of your IP. So that's one point, that whether that's in the US or that's globally. Same with third-party marketplace websites. So we're talking about Amazon, Alibaba, Taobao. In these instances, what you want to think of is who is potentially gaining insights into my brand or my design or my invention. And in those cases, you want to be defensive in the sense that you want to protect your IP in each market, not just in the US, because a US trademark, as was mentioned by my colleagues Brian and Deborah, is territorial. So a US trademark, a US patent will not protect your brand or your invention in a foreign market. You have to go country by country in protecting your intellectual property. And that is the best, I would call, defensive and offensive IP strategy to protect your fully comprehensive IP portfolio. So those are examples of how you have to think. I also like to parse out company situations and say, are you potentially importing a bolt or a component to your product from China? That's exposure already there. So you have to think of a defensive strategy as protecting the invention or the trademark or the copyright in China. And not to be too negative tonight, but China tends to be 97% of counterfeit goods originate or are manufactured in China. So a great defensive strategy, as mentioned by my colleague Deborah earlier tonight, if you first register your trademark or patent or copyright in China, you can enforce it, meaning you can prevent the exportation or dissemination of products from the Chinese borders globally. So that's a great strategy from the get-go. Lastly, going to the other question, Tricia, the issue you want to, or how you want to approach resources, if you're an SME, you want to visit our website. So the US government created a really nice website. It's stopfakes.gov. That's stopfakes.gov. I'll write it in the chat later for you today. And one of the great features of this website, it's a multi-agency. So the USPTO, US Department of Commerce, several US government agencies provide input into this website. And for example, if you want to register your trademark globally, we have links where you can go. And for example, it's the link is for the Madrid Protocol. So we like to call it the one-stop shop. You can check all the boxes of all the different countries globally where you want to protect your IP. And it, in a way, farms out your applications to expedite the process. So that's another great feature if you're a small company. And again, my last big caveat or warning, please hire an IP attorney, as we have them on the call today. They facilitate your protection and make it more efficient for your company.
Raquel, thank you. I'll note that all of our speakers at some point have been IP attorneys. So it just goes to show the importance of having an attorney engaged for this process is key. So Lori, I want to turn to you next. You heard Raquel say it, and then Deborah as well, focusing on where you should register, when you should register, what you should register. Can you help go a little bit deeper for a small business? It can be really challenging to answer those questions if you have global aspirations. What are some factors to consider when deciding the where, when, and what to seek IP protection?
Absolutely, and thank you to the organizers and sponsors for having me here tonight. I'm so pleased to be part of this panel. It's a great question. If you are a company that plans on selling, distributing, manufacturing, or sourcing your products internationally, then you want to make sure to protect your IP with each country's IP office. So for patents and trademarks, as has been repeatedly mentioned, it is territorial. You do need to register in each country. There are some treaties that will extend copyright protection globally to their country, but in some countries it does make sense, particularly in China, to go ahead and register it. There's additional protections available that way. So, you know, the question of where and when, I had a mentor early on who said, you know, register early and register often, you know, really get ahead of the process. And the reason is it takes a year or two, in some countries longer, to get a registration. And as has been mentioned, you don't want to get to a market and find out somebody's already got your mark. In terms of what factors to consider, I work with a lot of startups and small companies that are going into this process. And the things we talk about primarily are, where are your customers? Where are you selling? Where are your opportunities to sell? Because that's certainly a place that you're going to want to register your intellectual property. I'm a trademark attorney by trade, so forgive me, most of my examples are going to go to trademarks, but this also applies for patents. Where's your important market? That's where you want to register. But first you want to register in the United States. Do your home country first. It's relatively inexpensive. It also gives you opportunities for that are helpful when filing in other jurisdictions. So for example, if you file a US trademark application, you can then file in other countries within 6 months and get a priority treatment. So let's say you file today, December 7th in the United States, you can then go into other countries. And if you do so before June 7th, 2021, you're going to get the same filing date as your US application. So there's a wonderful priority treatment to consider there. In addition to where your products are sold, where are your products manufactured? It's been mentioned that China is a major source of counterfeit products. And so you want, if you're manufacturing in China, we help our clients register their marks there. It allows not only to register with customs and have a basis for enforcement, but also to watch for gray market goods. There's really a lot of opportunities to register where you're being manufactured. The biggest problem, I think has been mentioned, is just really don't delay. There's a lot of opportunities here where partners, distributors will see an opportunity to go ahead and register your mark in their country, and particularly in countries that are first to file. You end up with trademark squatters. It is always more expensive to get a trademark back from someone than it would have been to register it yourself in the first place. So before you start talking to manufacturers, distributors, partners, go ahead and apply to protect your intellectual property in that country in advance. Another consideration is, where is there a lot of infringement? Which countries are first to file? I think it's been mentioned that some countries, unlike the United States, where you can have trademark rights based on common law simply by using your mark in commerce. But in other countries, it doesn't matter if you've been using your mark for some time. If you haven't registered it there, it's the first to file in that country that gets the senior trademark rights. So also something to consider. So we look very carefully at Asia and South American markets, the Middle East and Africa. Many of those are first to file countries. And so if you are looking, for example, at the UAE, that's a first to file country, and there's also many opportunities for counterfeit products to come out of there. The other thing to consider, which is a little more subjective, is, in addition to where your customers are, where your manufacturing is, where's their counterfeit, where would you be really upset if somebody beat you to that market? If there is somewhere that just looks, really important, it may be 5 or 10 years down the road, but it's really important and you would be upset if somebody got there first, go ahead and look into investing the time and the resources to registering your brand there. One of the things to consider, and Deborah mentioned this early on, is that your registrations are assets of the company. And so they not only protect you, but they put the world on notice that you have trademark rights, that you have the savvy of registering your mark, and that you're somebody that's going to step up and enforce those rights. And so better to move on to somebody else that maybe isn't as on it as you, whereas if you're demonstrating a clear intention to register and protect your IP, a counterfeiter may just move on. So be proactive and keep in mind that it takes some time to get that registration. So get in ahead of the pack.
Lori, thank you so much for that advice for our startups participating tonight. I want to turn back to Brian, to you. This is you have U.S. government on the webinar tonight, and so we do want to focus a little bit on what the U.S. government is doing. In your long, illustrious career, you worked for the Office of the U.S. Trade Representative, responsible for the IP portfolio. So I was hoping you could talk a little bit about how U.S. free trade agreements and other international intellectual property agreements can be useful tools for startups prior to entering overseas markets.
Sure. Thank you very much, Tricia. Appreciate it. One of the things that's important to do, and some of my colleagues have touched upon this, is to know what kind of risks you face in a foreign market in terms of counterfeit or piracy, and how do you mitigate those risks. One of the ways is to look to see whether the country that you're thinking of entering the market to with your IP asset is whether it is a free trade agreement partner of the United States. The U.S. has about 14 free trade agreements right now currently, and each of those FTAs have an intellectual property chapter, which establishes higher levels of standards of protection and enforcement. Most countries are WTO members throughout the world today, which they're obligated to comply with basic minimum standards of protection. For example, copyright's 50 years. But US FTAs basically bring the FTA partner, whether it be Colombia, whether it be Korea, whether it be the Canada and Mexico, in line with US standards of protection in terms of protection, in terms of registration processes, in terms of eligibility, in terms of enforcement. So knowing that your country that you're thinking about exploiting your IP asset into is a free trade agreement partner of the United States provides a certain certainty of the rule of law. It provides more certainty in the market. You can look up at the FTA and see with that particular country what types of protection are provided. And again, in general, they are in line with US standards of protection. It helps you understand what the enforcement measures are available for you in those countries. It also provides new tools of enforcement in those countries that didn't exist before. For example, statutory damages, which if you are a copyright owner and are doing business online on the internet, it provides, it's difficult to ascertain what kind of damages, because it's impossible to decide how many downloads of the infringing material have been provided. But having statutory damages serves as a deterrent, but also provides you a certain amount of money that you could be remedied with by having that. The US FTA agreements also provide for what's called ex officio authority at the border. We've talked about some of our colleagues here about enforcement and prevention of shipment of infringing materials through cross-border transactions. The ex officio authority allows customs authorities in these countries to seize counterfeit goods without having to wait for a court order. So that's very important in terms of speed and effectiveness in helping to prevent the cross-border shipment of counterfeit goods. So FTAs can be a very important tool, both in knowing ahead of time that these countries or these FTA partners provide a rule of law and a certainty in the market. Other types of agreements have been alluded to as well, can help you register your marks or your patents in several markets through one application. The Madrid Protocol allows you to, through one application in English through the USPTO, to apply for your trademark registration in several countries around the world, all through one application, all through English, rather than going through each separate country, in their language and with their particular patent and trademark office. So that's a convenience. The Patent Cooperation Treaty, or the PCT, allows the same type of mechanism, allowing you to use one application using the USPTO to apply or register your patent in several jurisdictions, again, through one time. So the use of FTAs, the use of some of these international IP agreements can be very useful for you in terms of knowing what markets are better to go into in terms of protection, and also to facilitate the registration of your trademark or patent, through one application in English through the USPTO.
Brian, thank you very much for that overview. And in the chat box, there's the list of all of the countries with which the US has an FTA for your awareness. All right, I want to, Lori, turn back to you. As we all know, in the current business environment, there's been a major shift towards e-commerce. This is a great strategy for small businesses and startups to connect with customers around the world. We have a question in the chat box about our websites kind of considered IP. So I'm going to toss that question to you, Lori, but then can you just talk a little bit through what are the IP risks associated with e-commerce?
Absolutely. I will address the website question first. I assume you're referring to domain names. Typically, a domain name is considered a piece of property. It's an address. It's real estate, and so it is itself has limited in terms of IP protection. That said, if somebody has registered is using a domain name in bad faith that includes your trademark. Let's say you have a trademark registration for a particular brand and someone else has registered a domain name with that brand name in it and is registered and using that in bad faith, you can take actions. There are opportunities through the ICANN UDRP arbitration provisions where you can file relatively quickly and relatively inexpensively to recover that domain name. Again, it's quick and it's relatively inexpensive, and so it's a fairly narrow set of facts where there is a clear registration and use in bad faith. We work with a number of clients on recovering domain names that have their brand name in it through that provision. You can also file a lawsuit through various federal statutes, but in and of itself, just because you own a domain name doesn't mean you necessarily own a trademark. It's a separate registration process. I do occasionally get clients who are confused by that. Hey, but I have the domain name. Doesn't that mean I have trademark rights? Well, not necessarily, and it depends on the country. In terms of e-commerce, it's a wonderful opportunity for small businesses to extend their reach. But you're correct, there are a number of risks associated with that. Particularly the risk of pirated products and counterfeits. And so business owners really do need to take steps to protect their intellectual property or they face the consequences. Counterfeits are obviously a major international problem, and the risk of e-commerce has really exacerbated those. I think as someone mentioned earlier, you could stop a counterfeit product in swap meets that has one set of rules, but you add now to international platforms and it's so much easier to cross borders. It's so much more difficult to defend against counterfeiting. And in some of these e-commerce platforms, there's even sort of this added shine of legitimacy that appears on counterfeit products when it's very hard to tell the difference. So with so many counterfeit products coming out of China, it's increasingly a problem. So, there are opportunities for, on a number of these platforms, they have their own systems for reporting IP infringement, requesting takedown of counterfeit products. And, in many cases, this can be very helpful. Copyright protection tends to be more successful in terms of takedown notices through these platforms. The Digital Millennium Copyright Act, the DMCA, provides a number of provisions where platforms are given safe harbor if they follow a set of rules, which means if you report a copyright infringement, they need to take it down if it's found to be an illegitimate product. If it's a counterfeit product that violates copyright law, they take it down. And that can be anything from your logo, that can be your packaging, it can be a variety of ways, and often the copyright is more effective in terms of takedown notices than sometimes even the trademark. There are provisions for trademarks that you can report a trademark infringement and request takedown notices. On social media, there are often opportunities to report impersonation where someone is pretending to be your company or your brand. And so there are opportunities to take these actions. The other steps you can take as a small business is to, again, make sure you've registered your trademarks so that you have opportunities to enforce them locally in whatever platform you're on. Go ahead and register the domain names that incorporate your brand, the obvious ones, right? You can still point traffic to your main website, but go ahead and pick up the main domain names that would be obvious with your brand. The same thing goes for social media handles. Go ahead and pick up the handle that would be the most obvious with your brand. Don't wait to do that, in which case somebody may have already beat you to it. You can set Google alerts for free on the internet that can monitor traffic where people are talking about your brand, and sometimes that can pick up infringements. I also work with my clients to set up a trademark vigilance watch service, so it watches various registries around the world. It also picks up common law and trade name uses in the United States. And there are a number of companies now that have online software that can scour the internet and online platforms for counterfeit merchandise. And in those cases, that's often a collaboration between the brand owner, that software product, and the attorney, the IP attorney for the brand, to collaborate to find infringement, to find counterfeit products and take them down.
Lori, thank you. I was going to ask a follow-up question of specific strategies. We all know with limited staff, it can be really hard to do that monitoring, but you mentioned the Google alerts and other online software that's available. Brian or Raquel, do you have anything you want to add on specific strategies to monitor online to make sure there's no infringement happening?
No, I think Lori's covered it pretty well.
Okay. But Raquel, I'm going to turn to you. Speaking of online piracy and counterfeiting, USTR publishes a Notorious Markets list each year. What is that report and how should small businesses use it?
Sure. Thank you for the question, Tricia. So the Notorious Markets list report is a little report produced by the White House and the Office of the U.S. Trade Representative. It's not very well known, but it's very important as during COVID, sales and purchasing has gone mostly online. This report monitors in a very narrow scope bad actors or websites that facilitate the sale of counterfeit goods, including anything from COVID related products. You could think of that too in that scope, masks, PPE, and anything from websites that also facilitate illegal streaming or copyright piracy. So they facilitate viewing of sports channels and movies. That's going to be on our list, the Notorious Markets list report, as well as trademark counterfeiting. So your typical fake Louis Vuitton purse or fake bags and clothing, Nikes. The US government actually receives input from industry, from trade associations, from brands who basically are complaining that these websites are facilitating the sale or the transaction of counterfeit goods. And that affects not only US brands, but that confuses consumers. Consumers are purchasing what they may or may not know are illegitimate or even ineffective or even more dangerous products that can explode if it's like an electrical product that's counterfeit. That's actually not the best way to be purchasing products on a website that, again, facilitates the sale of counterfeit goods. So the way that you would use this report for your business, I usually recommend companies go to the NML website. It's produced again by USTR. We're going to put the link on in the chat. You'll see it. It's an annual report. Usually it's released between January and April of every year. So currently you can view the 2019 Notorious Markets List report, and you're going to want to look at the big players, and it goes country by country and website by website, and typical notorious, what we call, websites that facilitate the sale of counterfeit goods would be your Taobaos of the world, your Alibabas of the world. And they are making a concerted effort to work with the US government to remove the bad actors or the counterfeit goods from their websites, but it's a long process. So we as the US government want to see your input. If you're a small business, if you're an inventor, if you're an artist, to understand where and which websites around the world are not protecting your IP. So going back to the beginning of the conversation, we discussed that you want to record or register your trademarks, your copyrights, your patents, and that's key. So for example, if you have a trademark in the US, that's great for a US-based website to facilitate, again, the takedown mechanisms that my colleague Lori mentioned just now. The website will not honor your IP unless you have that trademark in that country registered. So that's very simple, really, how it works. And so if you go to Alibaba, which is the largest e-retailer, e-commerce third-party marketplace in the world, you will not be able to enforce your trademarks, your copyrights, your patents if you do not have a Chinese trademark, a Chinese copyright, or a Chinese patent. So that's the first key to this, what we call takedown policy. So once you have all those registrations in place, then you're in a good position to enforce your brand or enforce your invention. And then you can request that these websites, hopefully they do it, they follow through, and they remove these counterfeit goods or copyrighted works or illegal streaming products on their website. So again, that's sort of the approach I would use for the Notorious Markets List report. It's sort of to figure out the IP landmines, where you should be looking before you start exposing your brand or your product lines globally, and understand where you should be more vigilant, where you should be monitoring your brands. And last point I want to add, the sister report to the NML report. So the sister, there's a lot of acronyms here, but I'll explain them. So the Notorious Markets List report is the NML. The sister report to that report by the US government is called the Special 301 report, which was mentioned earlier today too. That's a very key report that analyzes globally all scopes of intellectual property. So we're not looking at online, it's not narrow in scope, it's more broadly country by country, industry by industry. So if you're in the pharmaceutical space, this report will note Brazil and India have issues with IP protection in pharmaceuticals and enforcement in this space. So for example, one US beverage company that's pretty well known, Red Bull, came to talk to my office to figure out their global IP strategy to disseminate or to sell their products in certain markets as they were expanding and their products were becoming more important. So what we discussed is to figure out their 5-year and their 10-year plan with regards to their trademarks, their global IP expansion, and to figure out where we as the US government, based on this 301 report, how ineffective or effective will it be to enforce their brand in certain markets. So then you get sort of a lay of the land. India is going to be an issue for you potentially, and this is just, I'm just throwing it out there. Don't listen to the specifics. But India, for example, may have issues with trademark enforcement, or Brazil may have issues in the pharmaceutical space. So you sort of have this IP insurance or this IP mentality in mind, and you know how to approach each market. So those are the two big reports that I would reference. And that would be a great starting point to figure out how to expand your brand globally.
Raquel, thank you so much for going over those resources. Again, you will need an IP attorney at some point, but the more research and kind of online work that you can do, leveraging reports, websites, government resources, it can really help you be prepared for when you get to that point of going to see an IP attorney. Raquel, before we move on, we had also had a question in the chat box kind of related to protecting your goods in the Chinese market. There's been several references about protecting counterfeits that come from China. And you kind of mentioned this in your comments. You need to be registered in China to be able to go through the takedown process, et cetera. So can you just touch on that a little bit more, just to really clarify, if you are selling in the Chinese market, what you need to do?
Mm-hmm. Yeah, very good question. So the Chinese middle class is growing and they have a lot of buying power. So that's a great place to think strategically about your intellectual property. The key there is to really scope out your IP portfolio. So some companies think that they have a trademark and they have a copyright, and they confuse one with the other. Patents, trademarks, copyrights, they're all very different. So first point is go to stopfakes.gov. Again, I'm going to put a plug in again for my website, and you can look there and figure out, it's sort of a tutorial on what is your IP. Then I would hire an attorney. It's very complicated to figure out what's in your IP portfolio and what's, which bucket to protect. So for China, I would focus on trademarks. That would be my number one there. And also you have to think of China as a totally different market with a totally different set of laws. Their trademark laws are very nuanced and very particular compared to US trademark law. And, without getting too in the weeds on that discussion, what I mean by that is when you protect your trademark in China, there's a lot of classes, which means groupings of goods associated with the brand. So if you're Nike and you have a group of goods associated with shoes, right, or apparel, within China, there's a lot of subgroups. So it could be jackets, it could be handbags, it could be different subsets of apparels. And if you're not essentially purchasing each subset of trademarks for that brand, you may miss something. And then the bad actor, what we call in the US government the bad actor, is going to come in and register your brand under their name. So then you lost rights in that space. So I think the big takeaway here in China is to be very careful in how you protect your IP, very thoughtful and methodical, and hire the best attorneys, I would say, to advise you step by step so you don't have issues in China. That would be my biggest defensive strategy advice.
Brian or Lori, do you want to add anything to that based on a question that we got from the audience?
I would love to. Raquel, thank you for highlighting the very specific and nuanced system in China. I approach registration of trademarks in China very differently from other countries in the world. And so when we're working with clients to protect their marks in China, we look at not only registering the English letters for their mark, but do they have a Chinese translation? And how well is that Chinese translation going to read with the local population? I mean, Deborah touched on this earlier. Cultural considerations, language translations, how does this brand translate into the marketplace? And do you have a Chinese character version of your trademark? Because if you don't, you will eventually, and someone else may register it ahead of you. So better to take control from the outset, choose a Chinese brand, register it, protect it. And when you're registering it, we work with clients to not only protect their core goods, so in the Nike example, the shoes, but also to pick an item from each one of the subclasses so that you are protected across the board. Early on in my career, I worked with a cosmetics company that had registered, their very basic cosmetics in China, and then had a real problem with counterfeits. And in this case, the counterfeit had registered their brand, believe it or not, for cosmetics for animals. Well, that's a different subclass. They were granted a registration by the Chinese Trademark Office, and we're using that defensively. Now, we work with local counsel, we worked with the local government, And at the end of the day, we canceled that registration. We worked with the police and conducted raids on their warehouse, and we were ultimately able to shut them down. But it just tells you it's a very different process in China. So I think it's very good to work with counsel that is experienced there, that is working with local counsel that's well connected through the trademark office and the customs and border control government agencies.
Thank you, Lori. Brian, I want to give you a chance to say anything on IP in China if you'd like to add any thoughts.
Sure. I just to build on what Lori and Raquel have already brought up, which is pretty comprehensive. But I think focusing on the enforcement side of it, sometimes it will result in having you to engage in litigation to stop the infringement activities in China. And again, the importance of working with local counsel to work through that system, understanding the local rules, the threshold of damages under which you can file a case, which court or administrative agency do you work with in pursuing the litigation in China. So again, knowing the local rules, working with local counsel is key to successfully navigating a very complex system over there in China in terms of if it comes to the enforcement side of protecting your IP.
Thank you. There's a note up in the chat to ask your questions now. We are coming to kind of the closing moments of our webinar. Can't stress enough, you need an IP attorney. You've got several of them here offering advice for free. So please put your questions into that Q&A box. And while we wait for a couple of questions to queue up, Lori, I'm going to kind of turn to you. If you can just really quickly, we've kind of gone over the approaches and the strategies for creating your IP strategy. Now thinking more of the defensive side of it, steps do need to be taken to prevent pirated goods or counterfeit goods from coming into the US. So just because you have the protection, doesn't mean it's automatically applied. Can you just walk us through a little bit about what you need to go about to make sure that you're actually protected if you are kind of victim to counterfeit goods?
Sure. I mean, once you have a trademark registration or a copyright registration, you certainly can and should record that with Customs and Border Control. This gives them a tool when they're looking at incoming products to stop counterfeit and pirated goods, and really gives you a basis to catch those right at the border. I've also worked with clients to record those with the Chinese Customs and Border Control, and so that you catch them at the source. And that can work in a number of different countries. I mean, we've had companies that have had counterfeit products in Brazil. And so one thing we traced back the source, we found it was coming from China, and we really worked with Customs and Border Control in each to make sure that the registrations are recorded. And then you need to work with the government officials to educate them as to which products are legitimate, right? You don't want to be stopping your legitimate products. Maybe you have manufacturing in China, and so you don't want those legitimate products to be stopped at the border. So you need to educate them. Who is authorized? Who are your manufacturing sources? Who is, what do legitimate products look like? To the extent that you're aware of counterfeits, what are the flags? What are the details? And there are sometimes business strategies that you can put in place that, I've seen people use holographic tags and labels and stickers that are a little bit harder to counterfeit. Counterfeiters are quick and they learn these things, but it's just something else to track, that if it's missing, it's one more thing that indicates that it's a counterfeit product. So really working with Customs and Border Control, I think, to record your intellectual property, and then giving them the education of who are your legitimate suppliers, what is legitimate product, and flags, any bad actors you're already aware of that they should look out for, can go a long way.
Thank you very much. All right, we do have one question queued up. My colleague Richard Swanson asks, can foreign companies improve upon your product and patent those improvements and then launch a separate product that would eventually compete with yours? Is that a strategy that competitors can use? For any of you.
It might be difficult because the requirements for patents in terms of being novel and there being no prior art could really restrict their ability to actually come up with an improvement and find it patentable. And I think it's also going to depend on whether you have a patent. So if it's a US company that has a US patent, but they haven't patented it in a foreign country, and then a foreign person comes in and tries to make some sort of change to it, hypothetically, could they make enough of a change that it would be patentable? Yeah, hypothetically they could, but it would have to be patentable in its own right. I think is what I'm saying. It couldn't be totally just small changes. It would have to be sufficiently novel and unique in order to reach that threshold for a new patent.
Thanks, Deborah. We have one other question, which I think is a really good one. When you need to find an excellent attorney who has a specific country or industry knowledge, where should you go? Raquel, I might start with you to answer that question, because I'm sure people, you know, come to the U.S. government for that question a lot. So what's, from your perspective, where would you send someone to find an attorney?
Yeah, so excellent question. Every country has their own set of intellectual property laws that are very specific, and expertise varies, you know, by IP attorneys. So from the US government perspective, I cannot recommend anybody. Everybody's great here on the panel, but I can't recommend anybody. But I would point each person to go to our embassy websites. Actually, we do have a list of recommended, vetted attorneys that are in country, so country specific attorneys that US embassy. So for example, if you're thinking of doing business in Beijing, you can go to our US embassy website in Beijing, and they should have like an up-to-date list of attorneys that the US government recommends in Beijing for each sector, so for IP specific questions. And I'd like to add one more plug too on the US government side. Not just for an IP attorney, but you can actually also, you know, benefit from the resources of, we have intellectual property attachés. So we have about 12, I believe now globally. And these individuals are usually attorneys. They're based in country. So we have 3 in China, in Beijing, Shanghai, and Guangzhou. One in Bangkok, in Thailand. We have in Russia, all over the world, in the EU, in Brussels. And these individuals are, if you're a US citizen, these resources are free. And I can assist you in coordinating a meeting with our intellectual property attaché. And what this attaché can do for you is, if you're thinking of going to market or in entering that market, foreign market, and you have specific questions, they can give you the latest information in each country, which is very beneficial. And if you're unfortunately having an infringement issue, in, for example, China, you can meet with our IP attaché in Beijing, and they can explain to you, you may want to file your trademark or patent case in this court. This is the best court for US companies. Don't stay away from that court over there in Shanghai, for example. And these are really important touch points that companies should have, and resources that we should have available to you. So again, if you want to know about these resources, stopfakes.gov, or send me an email. And those are two good avenues to find resources in each country.
Thanks, Raquel. Lori and Deborah, you two are both in private practice. Is there a professional association or any guidance that you would give to Sylvia here?
I think having a US attorney who is experienced in globally protecting the rights of US companies is a great place to start. So over the course of my 20 years practice, I spend a great deal of time developing international strategies and being able to really coordinate a company's movements globally and working with local counsel. I have contacts within just about any country that you can name, where I vetted those local associates, and I know them personally. As a member of the International Trademark Association, for example, that's a very great source. It's inta.org, and that's we have an annual meeting every year. I meet locally with my associates, and so I know them personally. We talk about updates to the laws and the systems, what's been going well, clients that may need a little hand holding or have specific issues. And so over time, you know, there's a number of us that, and Deborah is one as well, that this is our job. This is what we do. And so we spend our career developing exactly that network and being able then to work with our clients to select the right local counsel in each country.
100% what she said.
Lori, there's a small internet issue right when you're giving the website for the Trademark Association. Can you repeat that one more time for us? You cut out for just a second.
Sure, I'm so sorry. It's INTA.org. It's the International Trademark Association.
Perfect. Thank you so much. Brian, any advice you want to add to that, where someone should turn when they're getting started on this journey?
No, I think between Raquel outlining the government services and what Lori recommends, which I also recommend, is using a well-trained or well-experienced U.S. attorney that has that network internationally, I think are the two primary and best sources to try to locate an attorney to help you in a specific country's jurisdiction.
Thank you. All right, we are over our hour-long mark, but I do want to do kind of just a really fast lightning round to finish things off. If there's just one piece of advice you could give to our audience today, to U.S. small businesses and startups who are considering their kind of global IP strategy, what is that single takeaway that you leave them with? Brian, I'm going to turn to you first.
Do your homework. I think that's, you know, before you go into any market, know the risks, know the level of protection. You know the local rules, as I mentioned before, and make sure you file and register early, but do your homework first.
All right, do your homework, coming from the professor. Lori, what's your one piece of advice?
You know, I would say have a good U.S. attorney who understands working with small businesses, understand how to, you know, get the most bang for your buck. How do you work within the Madrid Protocol or national filings, or work with the European Union in order to really stretch those dollars to get you as much intellectual property protection, and then has the network to enforce them and navigate the local rules. I think a good U.S. counsel can go a long way. Thank you.
Raquel, what's your final word for us?
Sure. So I usually like to say, you're never too small to think of intellectual property and protection. Think of it as an insurance policy. It's going to pay off in the end, the investment. And you want to scope out your IP portfolio, your brand, your product lines, 5 years, 10 years down the line, and protect now, because it's going to be too late if you put that off.
And Deborah, we started the hour together. I'm going to give you the last word.
I would say next to the United States, keep China in the forefront. Even if it's not where you're planning to go, it eventually is going to impact your business. So it should be at the top of your priority list in terms of protecting your marks and your other IP.
Thank you very much. Thank you all so much for your terrific insights. This was a fascinating discussion, and I certainly learned a lot. I'm really grateful that you could join us for this really important discussion on IP. It's so crucial to startups and small businesses. And with that, I'm going to turn it back to Michael to wrap up our session.
Thank you, Tricia.
Yeah, thank you, everybody. I know we're going late, so yes or no question to Raquel. Is there a charge to come to you if you are, well, obviously a little bit younger and nascent and smaller than Red Bull, to do a 5 and a 10 year?
Yeah, I like to talk to everybody, so anybody can come talk to me. As long as you're a U.S. company or U.S. citizen, I'm willing to talk to you. Yeah.
Yeah, that was a softball, because what we're trying to do here is introduce startup founders and entrepreneurs who have that global ambition to take advantage of the public sector resources that are available. But I think we all can admit they're tremendously useful and valuable, but there's a disconnect to the frenetic, founder who's always trying to put out fires and crisis of building a small business. How do they tap into those resources and take advantage of the programs like yours? And then, part of this is Los Angeles and Southern California as a market. The world, as Stephen Chung said the other night, comes to us because we're such a great global city. I've had the pleasure of Lori presenting at our accelerator cohorts, And I'm sure Deborah is the same. And of course, I'm not going to speak for you, but I'm pretty sure that most startup firms and startup attorneys will give you 10 or 15 or 20 minutes to answer those high-level questions to get your fundamental knowledge or your rudimentary understanding of IP protection underway, so you can eventually be a better client for them, right? We love Fox Rothschild, and there are a handful of other law firms that are always eager to help startups at no cost for that first 15, 20 minutes. So, and I should also say, one of our favorite people, Christine Peterson, so the director of international trade and investment for the city of Los Angeles, is a former, Obama's executive office representative for intellectual property. So we have expertise on all levels, coming at us as founders. I'm a startup guy, so I'm speaking from the founder perspective. So thank you to everybody for this. I